Welcome back, everyone. Today we're going to turn our focus to what happens after law enforcement does their job and arrests a suspect. We're going to discuss the trial court process that sex offenders go through post-indictment. As you may know, we are all afforded certain constitutional protections when it comes to the criminal court proceedings that we face. Today we're going to discuss some of the significant issues that are involved when it comes to the trial court process. Specifically, we're going to look at the sentencing process and predictive factors that will increase the likelihood that an individual will be convicted of a sex offense. Let's go ahead and get started. To begin with, we need to refresh ourselves with a small examination of the adversarial court system that we use here in the United States. This means that there are two sides of the argument and the case is decided by an independent third party. You have the defendant on one side and the state on the other when we're discussing a criminal trial, for instance. The jury or the judge serves as the independent third party based on whether we're talking about a full jury trial or just a bench trial. When we have a court case that is being processed, the prosecutor's office has the requirement to make an argument strong enough to convict the defendant. The defendant, who is protected by the Fifth Amendment, does not have to say anything the entire time that he or she is in court. The Fifth Amendment protects against things like self-incrimination and against double jeopardy. This means that the defendant does not have to testify, nor does the defendant actually have to provide a defense. However, it would be a smart thing to do so. The outcome of the case will also be affected by a few other things. Did the defendant take a plea deal? Most of you may be aware that a plea deal allows the defendant and the state to strike some sort of deal in exchange for a guilty plea. This may be in the form of a reduced sentence, reduced charges, or the elimination of some charges. Some defendants feel as though this may be a better option than taking their chances in court. If they went to a full trial, then they risk a longer sentence or of being convicted of all the charges presented against them. The type of defense attorney also plays a role in whether the defendant will be found guilty or not. If the defendant cannot afford an attorney, they have the right to use a public defender. While public defenders often try their best, they may have too many cases and are frequently overburdened by their caseload. Meanwhile, a privately retained attorney is better able to devote time, money, and resources to your specific case. However, we know that not all individuals are able to pay for a private attorney and may only have access to a public defender. Regardless, once the defendant pleads guilty or is found guilty in trial, then he or she will be sentenced. In state and federal court systems, the standard practice is to use a bifurcated trial process. This means that the individual is convicted at a different time than they are sentenced. Dependent on the venue and the docket, the sentencing might take place the very same day as the conviction, or the sentencing could take place weeks or months later. But at some point it will happen. The sentencing process means that the convicted defendant will receive a notice of their criminal sanction. If they are incarcerated, this might mean that they receive X number of years in prison, for instance. At the federal level, parole has been abolished, and most states have also followed suit with that as well. But parole is still an option for some. If there is no parole, then the defendant is serving a determinate sentence. This means that I have received 5 years in prison and I will serve all 5 years in order to be released. With indeterminate sentencing, there is more variation in terms of sentence length, and the defendant may be sentenced to a sentencing range of 5 to 10 years, for example. They would be eligible for parole after 5 years, but dependent on their behavior while in prison and the amount of remorse and reformation that they exhibit, they may have to serve all 10. Some crimes require mandatory minimums. This means that if you commit crime A, then your mandatory minimum sentence is X. The judge cannot sentence you to anything less than that, and you will have to serve at least that amount of time. However, dependent on things like your criminal record, the type of victim that you offended against, whether or not there was a weapon used, if you had co-defendants, or any other number of factors, then mandatory minimum sentencing can be enhanced and you can end up serving more time due to these factors. As part of the movement away from indeterminate sentencing, many states and the federal government have started to use sentencing guidelines, which allow for more uniform sentencing and less discretion provided to the courts. Basically, sentencing guidelines use a formula and plug in all sorts of information. This includes employment history, criminal history, marital status, prior experiences with victimization, characteristics about the crime itself, and the formula spits out a short sentencing range. Then the judge has to sentence the defendant within that range. It takes the human factor out of sentencing in an attempt to eliminate sentencing disparities and discrimination. But it also requires truth in sentencing. So, if the guidelines recommend that the defendant receive 5 to 10 years, and the defendant is sentenced to 9 years, for instance, then he or she will be required to serve at least 85% of that sentencing under truth in sentencing guidelines. The remaining 15% can be served in the community based on good time credits that are earned while the individual is incarcerated. But those credits can be taken away, and the individual may be required to serve a full 100% of his or her sentence. Traditionally, sex offenders are processed through the state court systems compared to the federal system. The federal government primarily handles child pornography defendants above all else. From the statistics that we see here on the screen, those individuals convicted of rape or sexual assault only comprise about 3% of all felony convictions at the state level. But of those who were convicted, only about 19% of those individuals did not receive incarceration sentences. So it's very likely that you're going to prison if you are convicted of rape or sexual assault. Generally, these felony offenders only have one charge. Nearly 70% of offenders were convicted of only one felony, compared to 20% who are convicted of 2 felonies, and a mere 15% were convicted of 3 or more felonies. So this indicates that sex offenders are committing offenses that are generally not very aggravated in nature and only involve one crime that is taking place during the commission of the offense. Finally, in terms of sentencing length, sex offenders are receiving pretty long sentences. Sex offender sentences are second only to those who have actually killed their victims. These sentence lengths vary based on the offense and things like criminal record, but on average, sex offenders are being sentenced to roughly 9 years in prison compared to all other types of felons who have only received 3 years in prison on average. We spoke briefly about the plea deal process earlier in the lecture. Sex offenders are slightly less likely to plead out compared to all other non-sex offender felons. Any idea why this might be? Perhaps they weren't offered a plea deal. Perhaps they were more willing to take their chances at trial due to the stigma that is associated with being a sex offender. A small chance of a not guilty verdict and a life off of the sex offender registry may be just enough incentive for some to take that chance at trial. So let's compare whether or not that risk paid off. Those that went to trial were only slightly more likely to be incarcerated than those who took the plea deal. So that's not that great of a gamble, but let's look at sentence length. Those who took the plea deal went to prison for roughly half the amount of time compared to those who went to trial. So you can see the appeal of the plea deal for some in terms of sentencing length. I might rather spend close to 6.5 years in prison compared to a full 13 years of incarceration. But the plea deal is only going to take you so far. There are some other determining factors that are going to play a role in the sentence that you receive. When we talk about sentencing, 2 of the largest factors that are going to have an impact on the sentence that you receive are the seriousness or the severity of the offense and the criminal history of the individual offender. The first factor, offense severity, is really talking about how impactful the crime was, how serious the crime was, how violent the crime was, who was the victim, was a weapon used, did the defendant have a co-defendant. The more severe the crime is, generally the longer the sentence will be for the offender. The second determining factor is criminal history. Generally, first-time offenders receive less of a sentence than habitual offenders or people with a prior criminal history. If you are a first-time offender and you commit a pretty severe crime the first time around, you are still eligible for a long prison sentence. But traditionally, when someone has a significant criminal history, then that person is going to receive a longer prison sentence than someone who does not have a criminal history at all, meaning no prior offenses or convictions. The reason for this is that typically when someone has a repeat criminal history, it indicates that they have not learned their lesson or haven't done anything to show that they have reformed themselves, and this looks bad in the eyes of the court. Therefore, they receive a longer prison sentence. As these two come together, their intersectionality will play a large determining role in the type of sanction that an offender receives. One of the biggest issues with criminal history is that when your record is run, someone will see everything that has ever taken place within the criminal justice system. This means items that you were convicted for, events that you were only arrested for but not convicted on, and everything else in between. If you received a parking ticket or a traffic citation, that will be on your criminal history as well. When it comes to sentencing in court, the court has access to all of this information. They're not going to use your traffic citations to increase your criminal sanctions, but they're only going to look at your prior convictions. If you were arrested for something but never convicted, meaning that you were found not guilty, or maybe the charges were dropped, then this is not a formal conviction that the court can use as a way to increase your current sentencing. They can only use things that have been completed. However, more goes into your sentencing structure than just your criminal history. Things like victim characteristics, whether or not you used a weapon, the severity or harm that was caused during the commission of the offense, and personal offender details such as your education history, your income, employment history, race, ethnicity, gender, and age have all been shown to have some sort of impact on your sentencing outcome. So I know what most of you may be thinking right now. How is the court able to take things like my race, my ethnicity, or my gender into account when they sentence me? And basically, the court is not sentencing you for being black or being a woman or being Hispanic, but we might end up seeing some sentencing disparities that come into play based on these characteristics. So while it is not maybe happening intentionally that black defendants are being sentenced differently than white defendants, it is still happening. For instance, let's compare sentencing outcomes for offenders who are sentenced in simple and aggravated rape cases. In an aggravated rape case, what we see is that the offender committed some sort of violent action that goes above and beyond the force that is necessary to complete the rape. In a simple rape case, the offender only uses the force that is necessary to complete the rape. So it would make sense that there should be a difference in terms of sentencing for these two types of offenders. When it comes to sentencing for these types of cases, one of the biggest determining factors comes down to the victim's characteristics. In simple assault cases, what we see is that individuals who rape someone that they are previously acquainted with, then the jury may have to figure out who is telling the truth. This is a very difficult thing to process, but remember that in simple rape cases or simple assault cases, there is no violence occurring and relatively no injury to the victim. So, if the offender makes the claim that the sexual contact was consensual and there is no corroborating evidence such as injury, then the victim has to figure out who's telling the truth in what might be a he said, she said situation. For instance, is the victim at all fabricating or exaggerating the story? Or is the offender trying to negate the harm that was caused to the victim in an attempt to receive a not guilty verdict? It is a difficult question to process, especially for a group of jurors who have only had the testimony of the two parties involved as potential evidentiary support for this case. Comparably, when the offender and the victim have no prior relationship, meaning they are strangers to one another before the assault occurred, then research shows that it is easier to secure a conviction. Additionally, if that offender had a prior criminal record, and if the victim was willing to testify and cooperate with law enforcement, then a conviction was also more likely to occur. Finally, any time there is corroboration, in particular when a witness can testify, then it is easier to build a case against that defendant. In terms of sentencing and punishment structure, stranger offenders are more likely to get longer incarceration sentences compared to those offenders who had a prior relationship with the victim. So this indicates that the criminal justice system also somewhat buys into the stereotypes regarding offenders, meaning that the court feels as though a stranger offender has caused more harm or has committed a more serious offense than someone who was known to the victim. In comparison to stranger offenders, when prosecuting an offender that is known to the victim, the district attorney has to have a little bit more credible evidence in order to secure a conviction. For example, it was easier to convict if the victim had visible injuries, but those are typically not present when we have a known offender. This indicates corroboration to the victim's story and suggests that the sexual encounter was not consensual. If the offender was arrested for more than one thing, meaning multiple offenses happen that are related to the crime, or if the offender has provided any sort of incriminating statements, then the conviction was easier to achieve. Similarly to stranger offenders, it is always easier to secure a conviction when the victim reports the crime or cooperates with law enforcement, or if there is any sort of corroborating evidence from victim or witness testimonies. So let's talk a little bit more about the victims and their role in prosecution. When the sex offender had a child victim, that individual typically received longer prison sentences than someone who had an adult victim. Offenders who are related to their victims typically receive less prison time than offenders who were strangers to the victim before the event occurred. This is similar to what we discussed in the prior slide when I stated that courts believe that stranger offenders cause more harm to the victim than someone who is related or is an acquaintance of the victim. And then finally, as we know from all types of sentencing literature, the more charges that an offender has or is convicted on, the longer that the prison sentence will be. Like with all discussions surrounding criminal sentencing, we have to discuss the issue of sentencing disparities and sentencing discrimination. When we talk about a sentencing disparity, really what we're discussing is something that is totally different than sentencing discrimination. Sentencing disparities occur when two offenders commit the same crime but receive different sentences or punishments. This could occur for a variety of reasons. Perhaps offender A had a longer criminal history than offender B. Maybe offender A had a co-defendant, or offender B cooperated with the state and turned over evidence, resulting in a lowered sentence. Perhaps someone took a plea deal. There are a variety of reasons for why sentencing disparities occur, but they happen for legal reasons only. Sentencing discrimination, on the other hand, occurs for non-legal reasons and focuses on some of the basic characteristics of the offender. So this could happen based on the offender's gender, race, or ethnicity. Anything that is based on a singular characteristic of the offender can be classified as discrimination. But one of the criticisms that these two issues present is that there is often a thin line between disparity and discrimination, and sometimes they do intermingle. We'll talk about what I mean in one more slide when we focus on disparities in sex offender sentencing, with a particular focus on gender. Overall, when we talked about sentencing in a general sense, one of the most highly researched factors is the idea of race. From a corrections standpoint, minority offenders, specifically black offenders, and even more specifically black male offenders, are much more likely to receive prison time than their white counterparts. Even if white offenders receive prison time, black offenders are much more likely to receive significantly longer sentence than their white counterparts. This has been a problematic issue within the United States for decades, and it has not been fixed. One of the biggest contributing factors to this sentencing discrimination based on race has been the continuously used sentencing structures that focus on drug laws in this country. Alright, so when we're talking about sentencing disparities for sex offenders, the biggest factor that we have to focus on is the idea of gender. So if you remember back to the beginning of the semester, one of the things that I told you guys was that the vast majority of sex offenders are men, meaning that over 90% of those who are on publicly available sex offender registries are male. Women are just not committing sex crimes at the same rate that men are. But when women do commit crimes, and they're similar in nature to men, we're seeing a sentencing disjunct take place. On this slide, you can see some of the research that was conducted by Rosenmerkel and colleagues in 2009, and what they did was focus on some of the sentencing outcomes for sex offenders based on gender. So what they found was very similar to what we were talking about earlier, that the majority of sex offenders, over 90%, were male and were convicted of sex crimes in the United States. That leaves a very small proportion of sex crimes that are being convicted or committed by women who are getting convicted. But if you look at felony convictions overall, regardless of whether or not they are sexual or non-sexual based crimes, what we still see is that a large proportion of those crimes are being committed by men, and that women are making up a much smaller proportion of the total pie. So looking again at only sex offenders, for those individuals who were convicted, we saw that about 82% of men are being incarcerated compared to only 69% of women receiving a similar incarceration sentence. So there is a pretty significant disjunct in terms of the percentage of individuals who are going to receive a prison sentence here. Then when we look at things from a racial perspective, what we see is that even though there is a large disparity in general sentencing trends for all types of felony convictions based on race, the same does not exist for sex offender convictions, at least not on the same level. The majority of sex offenders are white in comparison to minority offenders, and when you have that many white individuals committing crimes, you're going to see that disparity slowly trickle away in comparison to the group, in comparison to when the groups are not similar in structure. So when we see sentencing for white and black sex offenders, we're going to see both groups receiving very similar sentences to one another. This does not exist for non-sexual felony sentences. Really, what we're seeing is that the disparities for sex offender sentencing focus more heavily on gender than they do for race. Okay, so down to the last thing that I want to talk about in this lecture, and that focuses on the idea of rape shield laws and how they protect victims during the trial process. Then we're going to end the day with a short discussion about victim testimony that is conducted via closed-circuit television, and then we're going to end for the day. So when we talk about rape shield laws, they really are all about protections that were developed exclusively for the victims, while still allowing the offender to be able to confront his or her accuser. Before rape shield laws were taken into account, the courts were allowed to ask victims about anything and everything pertaining to their personal life, not just about the circumstances surrounding the current crime. For example, before rape shield laws were introduced, a good defense attorney may focus on the victim's sexual history before the criminal event. If the victim was sexually active in a consensual relationship, then the defense attorney could use this to their advantage by focusing on the victim's willingness to engage in sex at other points in time. For example, if the victim was willing to have sex with my client last week, then it's very likely that this week's encounter was consensual in nature as well, and that the victim has simply lied about the events surrounding the alleged rape. Once rape shield laws went into effect, no one in court could ask about the victim's prior sexual history. Instead, they could only ask questions that were relevant to the case at hand. This was done in order to protect the victim's privacy, since the victim is not the one who is on trial. In addition, if you knew that all of this information would be dragged up in court, would that increase or decrease the likelihood that you would report your victimization to law enforcement? It would substantially decrease the likelihood that you would be willing to report to law enforcement, and that runs counterintuitive to what we're trying to do in terms of reporting. So we're only going to focus on the specifics surrounding the event. And once again, we're reminding ourselves that the defendant is the one who is on trial, not the victim. So there is no need to focus on the conduct of the victim at any other point in time. However, there is still one exception. There are still some times where the victim's sexual history may be of relevance to the particular case. For example, if the victim and the offender were in a romantic relationship, the sexual history between the two of them may be important for this case. But more specifically, the questions that would be asked would be geared more towards whether or not the offender was ever abusive in any other sexual encounters before now. Did the offender always get consent from you before this specific assault? Has the offender ever ignored your denial for sex before? Has the offender ever raped you before? These would be the type of questions that would be focused on rather than the number of sexual partners that a victim has had over the years. Furthermore, a judge has to determine whether or not this line of questioning could even be admissible at court. So all of this has to be done before the trial even starts. One of the constitutional protections that defendants have is the ability to face his or her accusers. So this could be the state, this could be the actual victim, this could be any and all eyewitnesses. Really, this means anybody who has a role to play in the charges that are being brought against the defendant. But what we mean by having the right to confront witnesses or to face their accusers is that the defendant may be physically present in the courtroom. And most commonly, witnesses are subpoenaed to come to court to testify or volunteer to come to court to testify, which further solidifies the defendant's right to face his or her accusers. However, when we talk about sex offenders having the right to face their victims, this might be a very difficult thing to ask of the victim. Imagine having to sit inside a courtroom for possibly hours at a time and having to be in the presence of the person who has just sexually assaulted you and who has inflicted what could be a possibly traumatic experience on you. That's a very difficult thing to ask of a person. So in some cases, courts allow the victims to testify outside of the courtroom in a remote, secure location through the use of closed-circuit television. This is not allowed everywhere, but can be approved on a case-by-case basis. Rather than subjecting the victim through a second traumatic experience, this type of remote testimony can be used in order to shield the victim, keep their identity hidden, and not require the victim to sit in such close proximity to the offender. This is typically something that is done more frequently for children than it is for adults. However, some adults, depending on the situation and the severity of the offense, can be given special permission by the court to testify remotely. However, it is not commonly done, but it is still possible. Due to this tension between offender rights and victim wariness, the criminal justice system has introduced alternative modes of providing evidence from witnesses. Several primary strategies have been employed: using screens or dividers in the courtroom, pre-recording the testimony through videotaping, utilizing closed-circuit television, as we just discussed, whether that's through one-way or two-way means, or closing the courtroom to the media or anyone else outside of the essential court personnel. There are two ways to complete closed-circuit television testimony, as I mentioned before. The first is through one-way closed-circuit television testimony, and it allows witnesses to be seen by the courtroom, but the witness cannot see what is occurring in the courtroom. They are closed off. The witness is in either a different part of the courthouse or somewhere else outside the courtroom. The second method is through two-way closed-circuit television testimony, which you should almost think of as a two-way mirror. This allows the individuals in the courtroom to view the witness and the victim, and for the witness or the victim to also be able to view what is going on inside the courtroom. Again, the witness or victim is in another location away from the courtroom where the trial is occurring. It simply allows for the victim to not be in close physical proximity to the defendant. Today we focused on a variety of different issues surrounding the prosecution of sex offenders in court. We highlighted the trial process and reiterated that close to 90% of all sex offender cases end in a plea deal with the state. Sex offenders receive much longer incarceration sentences compared to other types of felons, and due to determinate sentencing practices in most states and within the federal system, they will be serving nearly that entire sentence, minus any good time credits related to their behavior while incarcerated. Like any other case in court, the prosecutor's office is required to build a strong case against the defendant. That case is aided by any sort of evidentiary support, including corroborating evidence like injury or eyewitness testimony to the crime. But those things are not always present or possible to show in court. I thank you for your time in joining me for lecture today. I will see you next time when we turn our attention to the Catholic Church sex scandals and then later on towards sex offender recidivism. Thanks. Bye.